Yeah. Okay. Can you all hear me properly? Yeah. Hello.
Yeah, Monica.
Okay. Okay, so good morning and good afternoon, everyone. Welcome to this third and last session of the 6th Tarragona International Environmental Law Colloquium, jointly organized by the Tarragona Center for Environmental Law Studies and the Tarragona Environmental Law Students Association. Framed within the environmental law and the challenges of the decades ahead, promoting transformative and recovery responses to the planetary emergency, the current session topic is imagining alternative pathways and taking action. My name is Monica Pons. I'm a member of the organizing committee, and I will be the moderator of today's panel. Before starting, I would like to give you some practical information about this section and about this session and its structure, and some simple rules that we will follow in order to help us run this session smoothly. The agenda for today's section consists in a keynote speaker presentation of 25 minutes. It will be followed by 4 presentations of 12 minutes each, and once all the expositions are done, we will proceed with a Q&A session, where the speakers and the audience will have the chance to interact and further explore the topics presented. Finally, we will end up today's presentation and the 6th edition of this conference with the concluding remarks by the hand of Rahma Bentiro. We kindly ask the speakers to stick to the allocated times and to keep the microphones and cameras off while you are not speaking. The audience can make questions through the Q&A feature, the chat, or raising your virtual hand at the end. In case of writing the question, please let us know to who are you addressing the question and your name. And at the end of both the keynote speech and the panelist section, we will have time to discuss them. You can also use the chat to share any relevant information, not only questions. So we strongly encourage you to use it to interact with the other participants and the speakers. We remind you that this session will be recorded and broadcast live through Facebook. This said, we can start with the outstanding line of speakers and researchers joining us today. First, we are pleased to welcome and stay giving a warm welcome to the keynote speaker, Dr. Tanya Wyatt. Tanya is a professor of criminology at Northumbria University in Newcastle in the United Kingdom. She is a green criminologist specializing in wildlife crime and trafficking, non-human animal abuse and welfare, and intersections with organized crime, corporate crime, and corruption. Her research also focuses on crimes of the powerful and invisible crimes with the intention to challenge the society's definitions of crime and the failure to hold powerful actors responsible for harm. Professor Wyatt has published and edited more than 10 books on green crime topics and published more than 30 journal articles. Her latest publications are the textbook Crime and Power with Professor Pamela Davis and 2 forthcoming books in 2021. His site is Protecting Wildlife, Assessing Implementation and Compliance, and Wildlife Trafficking, the 2nd edition. Now I would like to give the floor to Dr. Tanya Wyatt. Thank you so much, Tanya, and thanks so much for being here today.
Yes, hello everyone, and thank you so much for the invitation to speak with you today. I'm not going to be speaking about wildlife trafficking specifically today. I'd like instead to talk to everyone about green criminology in general and also around earth jurisprudence and talking about how the combination of these might help us to not just sustain the planet, but to restore the planet. So first, I'm just going to introduce to everyone what green criminology is, and then talk about what earth jurisprudence is, and then provide an example and talk about how I think this could help with the future. What is green criminology then? I can imagine that maybe not everyone is familiar with this. So green criminology is, in its broadest sense, just a generic interest in crime and harm that is specifically related to the environment and to the planet. And it isn't by any means just a single kind of perspective. It's very diverse and has lots of different elements to it. It is really evidence of what gets called an integrative criminology. So where criminology as a discipline takes on parts of other disciplines, which really makes it a truly interdisciplinary field, green criminology in particular. There is the focus on what is criminal or what is regulated, what's against the law, I should say. So environmental laws. Green criminology does explore enforcement and prosecution and sentencing in relation to crimes against the environment. Monica kindly mentioned a book that I just got in the post this week around implementation and compliance with treaties and conventions. And my own work in this field has looked at the Convention on International Trade in Endangered Species, for instance. Green criminologists also explore vicarious liability and the monetary worth of environmental harm. And that's more of the, when we're getting more into talking about compliance and regulation. So regulation is another element to green criminology. And so this isn't necessarily criminal kinds of regulation, though it could be. Here we could be talking also about exploring and researching administrative and civil elements to how we manage the environment. And this particularly gets into ideas that the environment is a natural resource that needs to be monitored and controlled. Those systems of laws are designed to protect and preserve. We might take a species approach. So I mentioned around CITES, so how we protect an endangered species might be a specific law protecting one individual species of wildlife, but it could be a specified environment. Maybe we're looking at a national park or a area of scientific interest, for instance. And regulation is much more about managing negative consequences. And particularly if we're talking about industry behavior, industry practices, regulation is just trying to mitigate or keep the negative impact as low as possible or within limits, rather than banning it completely or not allowing any sort of activity. Green criminology is also about environmental harm. And here this gets into what we talk about in terms of critical criminology, which is a larger field than green criminology. And what I mean by critical is that we are not only looking at regulation and criminalization or just what's within the confines of law or regulations. Harm is any kind of activity that is causing suffering or causing injury. So this pushes the boundaries, and green criminologists like myself are challenging what should be criminalized. Are there activities that are injuring and harming wildlife or the environment that we shouldn't be allowing? So an environmental harm and a harm-based approach to what is green crime or environmental crime takes a much wider conception of what crime might be. And we push the boundaries and explore beyond what is strictly legal definitions. Rob Wyatt, probably the preeminent green criminologist in the world, a professor at University of Tasmania, is talking about environmental harm deemed to be a crime regardless of legal status. So we're moving away from legal status. We're just looking at harm done to humans, but then green criminology is also quite powerful in looking at humans are not the only victims of environmental or green crime. We need to also be talking about the environment, non-human animals, and plants too, when we're talking about harm and when we're talking about crime. Green criminology also looks at transgressions that are harmful to humans, as I said, but much beyond humans. And in my own interest around crimes, it's the power as a concept when we're looking at crime. Green criminology is also really challenging injurious and harmful behaviors that are facilitated or at least supported in some way by the state, or maybe just not addressed by the state, so they're ignored or negligent about it. It isn't just the state, though, looking at corporations, possibly other powerful actors that are involved in either directly harming the environment, but maybe they're also using their power to actually shape definitions of what crime actually is, or if something is regulated rather than criminalized. So exploring those kinds of relationships as well between corporations and environmental crime, or state and environmental crime. What Rob Wyatt then talks about is what green crime actually is debatable, it's contentious, and it can be ambiguous. And so that's a lot of the research of arguments and discussions and proposals about how we can conceptualize this idea. Green criminology is also very global in nature. It has cultural elements to it. And maybe in its most recent iteration or proposals around it being decolonializing or southernizing, as my colleague, Dr. David Rodriguez-Goyes has talked about. And I think this is a really powerful kind of approach of green criminologists. What Katja Franco has talked about as looking at the world as a single space. It's not only a shared environment that we live in, but it's also a shared analytical, social, and ethical space too. And she talks about, and Hogue, you can see there, also talks about there being a need, an obligation actually, to include more than just humans, more than just certain humans in our social contract. So in this interconnected globe that we are of looking at the whole global community, and that global community extending beyond just humans. And part of that is exploring the links to production and consumption that are responsible for a lot of our environmental crises. That might be biodiversity loss or climate change. And Franco talks about this need to explore, she's not specifically talking about green crime, Katja is actually talking about global criminology, but it certainly applies in that it's an ethical imperative to look beyond our local or our nation, to look at the globe as a community, because all of the problems that she addresses in her research around migration, but I'm extending this to environmental problems as well. These are global problems that we have to tackle together. And a powerful element, I think, of green criminology too, that I alluded to is challenging the power dominance, so the hegemony of Western thought. I mentioned around southernizing criminology, or decolonializing it to, we need to look beyond the West for knowledge, solutions, prevention, other ways of existing with the planet that the West has ignored, forgotten, or suppressed even. So that global interconnectedness includes hearing voices from marginalized communities and marginalized people. So I think that's an exciting development in terms of criminology in the last few years. This isn't so dissimilar to actually what Earth jurisprudence is. Earth jurisprudence too is a more radical kind of approach to human relationship with the planet. And in a nutshell, what Earth jurisprudence is proposing is rethinking of Western, in particular Western legal systems, to be Earth-centric. So any kind of legislation, Earth jurisprudence is not just focused on creating more powerful environmental laws or a certain set of laws that are Earth-centric. The argument there is that all legislation, tort, constitution, property law should all be Earth-centric, and that we should be judging all of our behaviors as humans based upon what impact is actually going to be having on the planet. One of the key Earth jurisprudence scholars is Cullinan. You can see there at the bottom of the screen. So a colleague and I have adapted this from his 2011 work, where he proposes 5 principles to Earth jurisprudence. And the first you can see there is the universe is the primary lawgiver, not human legal systems. The idea behind that being that we should be operating within natural limitations of the planet that we live on. And that really has to do with natural resources, food production, consumption, and that should be what's guiding how we create our legal systems rather than what currently is existing in the West. And the second one, the Earth community, and you can see that this plays into what green criminology is talking about as well, of having a global community that's concerned with the Earth. And there is the right to exist, to habit a place or to be in a place for everyone, everything in the Earth community. So it shouldn't be up to humans to decide who or what gets to be where, who gets rights or what gets rights, that there is an Earth community that exists already. The rights of each being are limited by the rights of other beings. And this is trying to strike a balance between prioritization of one species or another, or preference for one species over another, trying to reach some way of reaching balance within the different communities of species. Human acts or laws that infringe on fundamental rights violate the fundamental relationships. And Cullinan's drawing on Barry's work here, what he called the great jurisprudence, which is the underlying thought behind this of the Earth community. And that's how we should decide what is illegitimate or unlawful, is if acts are violating the fundamental relationships that we observe in nature. And then finally, his fifth principle around what I mentioned about it being kind of a radical new approach. So we need to adapt our legal systems, but really adapt all of society, politics, economic, social systems, to be consistent with this Earth-centric premise. And that should determine our lawfulness and our systems, and maintain, at the core of this is maintaining the balance between humans and the other members of the planet. And I think really powerful within Earth jurisprudence and starting to gain a foothold, I'd suggest, in green criminology, is the fourth point on the fifth principle there around the promotion of restorative justice. Frankly, we shouldn't necessarily be talking about sustaining or sustainable kinds of development, just sustaining the planet. Do we want the Earth to maintain or be sustained in the state that it's in? No, I think we might be able to agree on that we should be around restoring, repairing. And part of that is focusing on repairing and restoring damaged relationships between us and other species, but physically restoring and repairing parts of the planet if we can. And this is in contradiction to having a rather punitive kind of approach too. So there's a real care ethic within Earth jurisprudence that I think is quite useful and quite powerful. So rather than having, if someone is convicted of an environmental crime or a wildlife crime, rather than having massive, lengthy imprisonment or going to prison or being jailed, can we not do something less retributive, less physically punishing, and actually work towards a more restorative and reparative kind of approach to justice and to punishment? And then recognizing all members of the Earth community as a subject. And that just gets back to the Earth-centric, but Earth community is recognizing all species, not just humans. The example I'd just like to quickly give is one that Dr. Jack Lanskin and I wrote in a 2019 article based on his PhD research around hydraulic fracturing, so fracking in the United Kingdom. And if you were to apply green criminology and Earth jurisprudence and these principles that they share around an Earth community, Earth-centric, that we shouldn't be engaging in behaviors that are harmful or destructive to the planet, what does that mean then for not only legislation that governs so-called natural resources, but what does that mean for human actions? Would something like fracking be allowed if we had an Earth-centric legal system, but an Earth-centric society as well? When we look closely at fracking, what are the potential risks or existing risks that we know from probably a wealth of evidence now of fracking around the world. Risk one is around the negative contribution to climate change. We know that fracking wells, yes, we might be collecting fuel that we might need, but that very process itself has a negative contribution to climate change. So there are greenhouse gas emissions during the drilling process, the equipment, the trucks coming in and out of fracking wells, and then of course, the eventual consumption of the fossil fuel itself is negatively contributing to climate change. So the industry as a whole, the process as a whole, and then the use of the shale gas, of the natural gas that is extracted, is problematic in terms of climate change. Risk number two has been documented in the numerous places, again, where fracking is taking place, is well integrity failure. So if, for those of you unfamiliar with fracking, it isn't just a single well drill like we might see with more traditional kinds of oil drilling. It's cracking down in and then spreading out across this. And what also then happens is that there's storing of the water, or it's not just water, there's secret formulas of chemicals that gets used to drill in them and then try to dislodge the natural gas. The wells that are holding this water and the drilling wells themselves fail. And so there is pollution associated with fracking as well. So this chemical mixture, this water leaking into the local environments, natural gas escaping as well. So lots of pollution issues in this process. And that links to risk number three around wastewater disposal. So I mentioned this chemical mix in water. Normally this would be stored, but I mentioned it fails, but also it needs to eventually be disposed of. But what happens to it? Where does it go? This is a contaminated source of water. How does it get treated to where that it isn't contaminated anymore or isn't toxic anymore? So there's those three risks linked to climate change, and then two that are really closely linked to pollution. If we look at fracking then from green criminology and earth jurisprudence, fracking is legal in many places. So it is, if we look at fracking from a green criminology lens, it becomes visible because it's a harm, not just a crime. And we see injury, potential injury. There are not just human victims that were associated with this. Wildlife, the environment itself is damaged by fracking and has to exist with the infrastructure and things. The global community, climate change, if we look at that as a risk or an impact, a negative consequence of fracking, climate change just doesn't impact the people where the fracking is happening, it's going to impact the planet. And challenging the idea that capital accumulation as central to what we need to be doing. The people that are involved in the fracking industry, can we not find them other opportunities for livelihoods, different ways to support them, rather than having the money associated with fracking being central to the decision? And if we explore fracking from an earth jurisprudence perspective, again, it's equivalent to the green criminology in terms of a whole earth community being similar to a global community, but earth jurisprudence perhaps highlighting more the interspecies nature of that community. Also, with all this contaminated water and the breaking up, the physical act of the process of fracking, how is the earth jurisprudence a challenge from damaging earth systems, breaking apart natural cycles, disrupting natural cycles? Also, earth jurisprudence would highlight the rights of other beings. And then it would also argue, earth jurisprudence, the human adaptation that's needed to the earth community. Can we not adapt how we are producing energy to be kind to the earth community, to be earth-centric, rather than to be so damaging? So I'll just leave you with the final point around, I think that the future what could our Western legal systems look like based upon what I've shown there around a green criminology and an earth jurisprudence. And it really is a complete rethink of our relationship to nature, and one I think that's desperately needed because of these variety of environmental crises that we have in terms of climate change, which is clearly relevant to fracking, but also biodiversity loss that is rapidly increasing. So I just almost give this as a call to action, but also as a call to exploration, that there are other ways that we could structure our society, particularly our legal systems, to be much more earth-centric and restore and repair the damage that we've already caused. Thank you.
Thank you so much, Tanya. That was truly interesting, and I think it was a great way of introducing today's topic, so thank you so much for that. Following Dr. Tanya Wyatt, now it's time to start with today's panels, where we will cover a wide range of topics. First, we would like to welcome Daniel Calval from the University of Coimbra. Daniel, whenever you want, the floor is yours.
Thank you, Monica. Good afternoon, everyone. First of all, I'd like to thank you for having me. It's such an honor to be with you today. As said, my name is Danielle Galvão. I am PhD candidate at University of Coimbra, and this paper, titled "The Environmental Law Effectiveness and Technology at the Service of the Environment," aims to assess whether the existing environmental law has been effective and how the use of new technologies can ensure the enforcement with environmental laws and the compliance with climate international commitments. So the paper is structured in 4 main topics. Firstly, it is analyze how the evolution of scientific technologies contributes to highlight the ecological crisis in the Anthropocene and how it arises as allied to the sustainable development. Secondly, it is argued that the transformations triggered by technological advances play an important role to build a more consistent environmental rule of law and a collective ecological sensitiveness to protect and preserve the environment. Thirdly, it is developed how technology used at the service of the environment could be an essential tool to enforce environmental laws. And finally, as a Brazilian lawyer, I exemplify with a Brazilian case how technologies such as satellite monitoring and geodata analysis may bring a great contribution, for example, to monitoring the compliance and the effectiveness of nationally determined contributions, the NDCs. So if on the one hand, the evolution of scientific knowledge and the horizons of new technologies come as allies to economic development, on the other, they highlight the ecological crisis in this new geological era that scientists have named as the Anthropocene, which is marked by anthropic interference in nature and the force that the humankind is able to exert to interfere drastically in the natural cycle of the Earth's life. Scientific studies show that the planetary boundaries, which aim to define the environmental limits within which humanity can safely operate, have been exceeded and are about to reach out the tipping point due to the pressure exerted by human actions on nature. And this whole scenario points to the configuration of an ecological crisis that is planetary. Through science, it is increasingly evident the emergency to which the Earth ecosystem is subject. And it is also through science that paths can be traced to active sustainability. We know we live in an interconnected world. There is no way to think of humanity apart from the whole to which it belongs, the ecological integrity of the planet. In fact, the COVID-19 pandemic, which is the reason we cannot be at an event in person today, is a clear example of the negative pressure that human interference exerts on ecosystems and highlights this interrelationship. Throughout these last 3 days, we have already heard other speeches reinforcing this, the interconnection that exists between the environment and human existence and survival under suitable conditions. And in this sense, if we are facing a context of planetary boundaries transgression and of the fragility of human existence, the transformations triggered by technological advances are essential for building a more ecological sensitive and environmentally committed environmental rule of law. Nowadays, technology at the service of the environment appears increasingly as a means to provide enforcement of environmental laws. We know environmental law does not walk alone. It is not, in fact, it should not be limited to the juridical perspective. A transdisciplinary approach is essential to achieve an effective environmental law. Through existing resources, it is possible today, for example, to monitor in real time the advance of deforestation in the Amazon. There are several types of remote monitoring systems, such as Planet, Sentinel, Landsat, Seizure, just to mention a few. So technology at the service of the environment is an essential pathway for the monitoring and enforcement of environmental violations. It is also a tool to be used for the development of adaptation and mitigation strategies, as well for building a more informed and aware society regarding the environmental problems linked to the ecological crisis. And an example of this is the arising cases of climate litigation all over the world, in which one can see a trend of charging not only the state, but now also against large corporations and polluting companies for their role in achieving a more sustainable world. And public participation, understood as the possibility of giving a voice to all those interested and affected by environmental problems, is essential in this regard, especially when it is informed by scientific knowledge produced by the use of technology at the service of the environment. So these technologies may bring a great contribution to monitoring the compliance and the effectiveness of the NDCs, for example. And in the paper, I use as an example to illustrate what is being argued here, a case of climate litigation filed in Brazil in April this year. It is a class action filed by 6 young activists against the Brazilian government, the Minister of the Environment, and the former Minister of the Foreign Affairs. Sorry. With the aim of nullifying the Brazilian NDC presented in December 2020 under the Paris Agreement. The plaintiffs argued that the climate goals presented in December maintained the same reduction rate set in 2015 of reducing greenhouse gas emissions by 43% by 2030. However, the government did not update the calculation base it used to calculate emissions. So, in practice, if in 2015 the 43% reduction rate meant emitting 1.2 billion tons of gases by 2030, the new goal with the same reduction rate allows Brazil to emit 1.6 billion tons in the same period. This would represent an increase in emissions of 400 million tons of gases than initially proposed in 2015. And the plaintiffs called this as carbon trick maneuver. The lawsuit is still in progress. It does not have a final decision, but besides that, this case is relevant not only because it will be a landmark case, but because it was only possible to understand that these goals do not match the requirement in order to be able to challenge them on proper and consistent grounds in court due to the use of technology, making use of available technologies at the service of the environment, a science-based approach. And it was through the scientific studies that these young activists could be informed to realize that there was a deficit regarding the enforcement of a commitment made by the government, not only at the domestic level, but also and especially at the international level. And this shows the relevance of the information that environmental technology provides in order to build an informed society and therefore comply with and also enforce environmental law so these laws could be more effective in practice. So to conclude, I just need one more minute. Instead of thinking of a strategy to put new norms in the legal system that many times may even represent setbacks in environmental issues, as we have seen, unfortunately, we have seen in the last few years in Brazil, it is necessary to think of ways to make the already existing laws effective. And technology at the service of the environment is a means to help strive for this and provide compliance with laws. So these are the reflections I have to share with you today. Thank you once again for the opportunity, and I'm looking forward for any further questions.
Thank you so much, Danielle. That was really great. Hopefully we will have some questions at the end. Up next, we have Sabrina Briziole from the University of Perugia. Welcome, Sabrina. As soon as you're ready, the floor is yours.
Hi. Thank you. I'm so pleased to join the 6th TIEC International Environmental Law Colloquium. Well, now I also thank all the organizers and the keynote speakers for the previous amazing panels. And now I will try to share my screen. Well, okay. Today, I will try to explain and show you the outcomes of my PhD research. And I will try to focus on a multi-risk integrated approach. Here you can see an overview of my presentation today. I will start by explaining what I mean by award at risk, focusing on the idea of risk and global preparedness, to then move to emerging infectious disease, more precisely zoonosis. And I would like to focus on the lesson learned and challenges posed by the COVID-19 pandemic. Then I will try to task environmental law in the post-pandemic, giving an alternative legal structure to face new threats. And I will show you the legal design of a multi-risk integrated and adaptive approach system. To start with the idea of awarded risk, the kind of global risk I'm referring to is the result of a dangerous combination of altered human behaviors, environmental changes, and inadequate public interventions in social and economic fields at the global level. To face this risk, the international community generally used the word preparedness. That is to say, the attitude of being prepared for a particular situation. The state of being ready for something to happen implies to take into account a vast array of factors. The Global Preparedness Monitoring Board and its report in September 2019 warned about the likelihood of global health emergencies and indicated 7 urgent actions to prepare the world. Some of the insights of that report are included in this scheme, but I've also introduced other relevant aspects to take into consideration. More precisely, the role of science, the enforcement of the environmental rule of law, and the monitoring of emerging unconventional threats. Among these latter ones, it is important to focus their attention on infectious diseases and on zoonoses. Despite the fact that the origins of COVID-19 are still unknown, relevant studies have highlighted that around 70% of infectious disease affecting people start from animals, and future outbreaks will be associated with ecological disturbances, such as deforestation, habitat fragmentation, urbanization, bushmeat consumption, and agricultural intensification. To trace the causality nexus, it is important to consider both pathogen characteristic environmental factors, but also anthropogenic drivers. Indeed, the spillover effect, that is to say, the interaction that enables cross-species transmission of pathogens, could be triggered by the misconduct of human beings. But actually, zoonoses are not only a sign of disconnection with nature, rather they are opportunistic and public disorders. They tend to affect those contexts stressed by social and economic vulnerabilities. Generally, 3 siloed sectors are involved: environment, society, and health, which are all very crucial for determining public security. The current pandemic has revealed that there were tardive protection of public health using quarantine and social distancing. States moved messily without strategic cooperation, and as proved by the United Nations Human Rights Office of the High Commissioner, governments have weakened environmental protection during COVID-19 pandemic. Instead of seeing government improve environmental safeguards, a progressive number of regressions have been registered, and many decisions, such as the restriction of public participation, have hampered rights such as right to water and right to health. The pandemic has also revealed the contradiction of multilateral systems, which were unable to synchronize their mechanisms. So, that said, I have questioned myself on how to task environmental law in the post-pandemic. Many scholars have suggested that environmental law has public health origins. So I have tried to find international law instruments which embody an interdisciplinary approach to health, environment, and security. To address the increasing interlinked health challenges while ensuring the biological integrity of the planet, it is important to strengthen a cross-sectoral approach. So, decoding the objectives and the perspective of the above-mentioned instrument, I have tried to imagine a transformative and alternative paradigm to tackle planetary emergency. This new legal design is grounded on values, principles, and human rights. Just to give an example, the value of solidarity, the principles such as precautionary principle, prevention, or integration principle, and among the human rights, the human right to a healthy planet. But the novel idea is to introduce disciplines such as green criminology, green earth jurisprudence, and also a strategic environmental resilience. In its current form, resilience is considered as the capacity of a system to absorb disturbances. But I think that it's important to have a new idea of resilience as the attitude to restore and to restore ecosystem, or to control risks, or to reconsider the conception of environmental harm, avoid the scientific reductionism, and also balance earth maintenance and anthropocenic processes. To consider green criminology and green earth jurisprudence, I know that the discourse around these two disciplines is complex and it is still in its infancy. But what I would like to say is to integrate these two disciplines into a multi-risk system. For example, what is important to know about green criminology, according to my point of view, is the fact that it not simply focuses on what it is unlawful and harmful, but also about what is lawful and harmful. Just to give an example, pollution is not a crime, but exceeding the permission of licensed pollution should be a crime with the devastating impacts on climate security and harmful climate change. Considering the bats exchanges, for example, bats are generally the reservoir of pathogens. The bat exchange is legal, but generally they are exchanged without documents that take into consideration the risk involved in taking them from the wild. So it is important to consider biopiracy, not human rights and eco-crimes. Concerning green earth jurisprudence, it could be considered as an approach to legal decision making and to take into consideration its principles such as integrity, balance, and adaptations. Then it is also important to, another important feature is environmental security. It concerns international relations, development, sustainable development, and human security. It concerns how environmental problems cross state borders and impact human society and public health. Here you can see a snapshot of a multi-risk integrated and adaptive system. I have included both the dynamic elements which I have introduced and functional elements which are already included in international environmental law instruments. The drivers of this system are citizen engagement, intersectional education, access to information, and environmental participation. And the triggers are, of course, external factors such as environmental changes, cultural, social vulnerabilities, economic variables, and scientific advance. The engine of this system is environmental rule of law. To quote the definition of environmental law given by the International Union for Conservation of Nature in its World Congress in 2016, it could be understood as the legal framework of procedural and substantive rights and obligations that incorporates the principles of ecological sustainable development into the rule of law. Of course, the reliable and useful impacts should be the ecosystem approach, integrated food system, health preparedness, and effective application of the access and benefit sharing mechanisms, especially for genetic resources, for the exchanges of genetic resources. To conclude, I think that the devastating social harm, human health, economic effects of COVID-19 should force the global community to jointly consider the features of pandemic crisis, health Earth's systemic decline and the rule of law. And it is important to break silos and to identify legal areas which are involved in an integrated strategies. It is also important to redefine and rethink about environmental harm. Environmental harm is generally considered as something that harms human being, but to give a realistic definition of environmental harm, it could be considered as something that makes the survival of life more fragile. So welcome preparedness mechanism to prevention, awareness, the trust in science, but it is important to foster a human rights perspective, also having the support of key principles such as solidarity, and to take into a closer consideration rights of nature, earth, or jurisprudence, not simply to achieve the sustainable development goals, but also to protect environment and guarantee social economical rights. I have finished. This is just essential references, and I really welcome further questions, and I really thank you for the attention.
Thank you so much, Sabrina. That was really great. I'm sure that we will have some more questions, and we have all the time at the end of the session to do all the question and answer that you want to do to the speakers today. So now continuing with the panels, our next panelist is Oriol Solà from the Ministry of Foreign Affairs, the European Union and Cooperation of Spain. I will highlight here, though, that the opinions expressed in this presentation are the sole responsibility of the author and do not represent the official position of the aforementioned ministry. Oriol, welcome, and thank you so much for being here today. Whenever you are ready.
Thank you. Let me share the screen with you all so we can see my presentation. That's good, right? Do you see it? Well,
yeah, that's great. Thank you.
Thank you for your time and your interest attending this session dedicated to an ecocentric proposal of a human right to the environment. I am extremely grateful to the organizers of the Tarragona International Environmental Colloquium for giving me the chance to bring onto the debate a different perspective, an alternative epistemology to lawmaking and understanding of the relationship between human beings and nature. This slideshow I made tried to set up the background and reasoning behind the concept of an ecocentric human right to the environment and lays out the definition and structure of such a proposal, which was the subject of my PhD thesis. What I'm going to tell you throughout my presentation will not be what you'll be reading on this slide. These are two complementary sets of text, as I understand that you will be able to go back to this presentation whenever you want. It's just that there are so many things I would like to explain to you all. So let's try to think as an ecosystem. You can choose a river, a mountain, a mangrove, any animal or plant that you fancy. And let's start our journey towards an ecocentric paradigm that advocates for a renewed definition of the relationship between human beings and nature from a human rights-based approach. The starting point of this journey is the global climate-nature emergency and the planetary band rifts framework. The world is experiencing a convergence of ecological and human crises, which many call the Anthropocene, with its quadruple squeeze on planet Earth and the great acceleration of the human enterprise. And this changes everything. As the 21st century is witnessing the failure of anthropocentric law, my understanding is that we have both an ethical and practical obligation to engage with this crisis, as we have a legal and moral obligation to future generations to leave the planet in as good or better condition than we found it. However, the paradigms, the concepts that currently dominate the disciplines cannot do so because they're still anthropocentric, focusing on short-term goals and the legal illusion of control of nature, as I explained in this slide. It is scarcely necessary to elaborate on the protection of the environment as a sine qua non condition for human rights, as damage to the environment can impair and undermine all the human rights spoken in the Universal Declaration and other human rights instruments. Fortunately, the attitudes that are sapping the environment's health and sabotaging the prospects for a viable future are not instinctive, but cultural. They can be changed by better understanding the evolutionary story that relates us to other organisms and by better comprehending ecology that dissolves the boundaries between ourselves and ecosystems where we live. Therefore, we need to enlarge our understanding of human rights, as people are ecological beings and people's rights and social responsibilities must be harmonized to that indisputable fact. The idea that human law must be understood in its ecological context raises questions about particular concepts that are often used in legal and political philosophy, and whether they need to be updated, such as freedom, agency, responsibility, justice, wrong, harm, accountability, and causation, for instance. And what's the scope of a new human right to the environment? The UN Special Rapporteur on the Environment and Human Rights explains that the human right to a healthy environment is not an empty vessel waiting to be filled. On the contrary, its content has already been clarified through recognition by human rights authorities that a safe, clean, healthy, and sustainable environment is necessary for the full enjoyment of the human rights to life, health, food, water, housing, and so forth. And not only substantive rights, but also procedural rights like access to information, public participation, access to justice, or free expression, freedom of association. That's why environmental rights are among the true cross-cutting issues. An ecocentric human right is a systemic alternative because an ecocentric perspective places the health of the ecosphere before human welfare, but it's not an anti-human argument. It engages with works across the humanities and science and perspectives from traditionally marginalized thinkers, feminists, indigenous communities, to utopists, to articulate and implement alternatives to the human-centered conventional laws, legal institutions, and legal worldviews. So now, let me sum up where we can find this ecocentric proposal of the human right to the environment. Within the planetary boundaries, which is that, you see, and at the intersection of the human rights doctrine and the rights of nature. That's where we find an ecocentric human right to the environment. Let me highlight some of the tenets of an ecocentric human right. We live on a finite earth, and our belief of expansion and growth as the only acceptable and right goals for a society is a fiction with disastrous consequences, because we exist in relation to a system of nature. We exist in relation to other generations, and human law ought to reflect and respect the biophysical laws of nature. Ecological sustainability is the basis of both social and economic sustainability and the protection of ecosystems, not only for their own intrinsic value, but also to permit them to maintain their life support function. The field is still young and rapidly growing, unsettled and broad in scope, so it may be still very confusing, and that's why I wanted to roll out some keywords, a syllabus that will guide ourselves along the journey towards an ecocentric paradigm, focusing on prevention, precaution, intergenerational, and interspecies justice, and future generations. Interwoven into the text of the Declaration proposal to the human rights of the environment are principles drawn from both soft and hard international law, including the Universal Declaration of Human Rights, from numerous non-governmental declarations and people's treaties issued over the past 50 years. contemporary science. Findings, the declaration and reports of UN conferences, the global ethics movement, and best practices for building sustainable communities. Therefore, in this slide, you will find most of such sources. And what is an ecocentric human right to the environment? Let me read you the definition. It is the right of all human beings, non-human animals, plants, and ecosystems to a natural environment where they can thrive and prosper, bringing an ecological sustainable development to the present and future generations by guaranteeing international protection and restoration of the integrity of the Earth's ecosystem. Ecological integrity means the ability of an ecosystem to recover from disturbance and reestablish its stability, diversity, and resilience. It should be foundational for all domestic and international law regimes as it breaches the concerns of science and public policy. So, support for the recognition of a human right to the environment in a global instrument is growing, and the recognition of the right could capture the meaning of the existing obligations. The Human Rights Council is particularly well suited to undertake this task, as it has been working for years on the issue on human rights and the environment. The model could be the 2010 General Assembly resolution recognizing the rights to water and sanitation. The proposed declaration sets forth the foundational principles, which are in turn supported by an extensive array of subsidiary principles, which provide practical guidance on how human rights obligations should be implemented in the environmental context. The full text of the declaration is 9 pages long. The preamble sets out its normative and factual context, priorities, and values, and refers to alternative ontologies and epistemologies. The declaration contains 12 articles addressing the relationship between human rights and nature, which includes 3 main categories: substantive entitlements, vindicating non-anthropocentric approaches to human rights and environmental protection. For instance, the rights of all to assistance when faced with a natural or technology disaster. Procedural entitlements are also developed, providing the means for non-humans to be politically represented through their human brothers and sisters, just like future generations. Finally, the declaration recognizes the need for enforcement of normative obligations in the form of duties placed upon states, corporations, and individuals alike. So, conclusions and open questions. I would say that reconfiguring specific legal concepts in light of an ecological worldview takes a great deal of courage. So in order to further our ecological understanding of law, my suggestion is that we keep studying the content, challenges, and obstacles to the full realization of the human rights obligations relating to nature. And we continue to promote and exchange views and test our dialogue and collaboration with all relevant stakeholders on good practices to enhance understanding and public awareness relating to human rights and environmental policymaking, especially in the area of environmental protection. And then we will be able to answer with much details whether an ecocentric human right to the environment is just a new label, and if there's a ceiling to the environmental state. Thank you. Think like an ecosystem. That's all. Thank you very much.
Thank you so much. That was really good. Thank you. Thank you so much. Okay, thank you. Now that we are arriving at the end, our last panelist today is Carlota Garofalo from the University of Graz, who will be presenting her research with Julia Interes from Peking University. Welcome, Carlota. Go ahead, please.
Thank you very much, Monica, for the introduction. I try to share my screen. I still can't, I think. I think the,
yeah, okay. Now.
Okay, so can you see it in full?
Yeah, everything's great, thank you.
Okay. Yeah, so yeah, thank you so much for accepting my abstract. It's great to be in this panel and to hear so many new perspectives on like this new way of relating to nature in general and so interesting all these normative perspectives. My paper is more, I have to say, empirical, or tries to be more empirical than normative, but so this would be interesting. So I'm co-authoring this paper with Giulia Interesse. She's a colleague, a PhD student from the politics School of Politics in the Peking University, and I am a PhD student in law at the University of Graz, Austria. So the agenda of the presentation will be the following. I will start with a short introduction into the paper and its main objective, and I will then explain something about the methodology that we used. I will then show the first results, at least, that we have found in our research, and then I will conclude. So the main motivation for our paper, for our research in this case, was to at least contribute to filling a literature gap, a gap in particular in the climate litigation literature, which concerns specifically the social and symbolic effects of climate change litigation. So we try to understand how climate change litigation can contribute in shaping the norms and values. So not only creating legal changes or political changes. And the research questions that we have asked ourselves are two. We have first identified two symbols for climate change action, in particular the polar bear on one hand and children on the other hand. And then we have seen how these two symbols have been framed in the general debate in the media around climate change, and how these frames have changed over time. And then we've assessed, or we have explored, the impact of these two symbols in climate change litigation, since they've also been used in relevant climate cases. So we've explored how the polar bear and children have been framed in relevant climate change cases where these symbols have been used, and if the frames corresponded in the two debates. So the two cases on which we have focused are the following: the Center for Biological Diversity versus Chemthorne on one hand, and the Juliana versus United States, probably a more known case as it is more recent also. In the first case, we have a more classical kind of environmental lawsuit. So we have different NGOs that try to have the polar bear recognized as an endangered species due to climate change. And they filed these cases back in 2007 against the back then in charge Bush administration. In the Juliana case, we have 21 young people that are supported by an organization that is specialized in climate change litigation, which is the Our Children Trust, and they are also aiming to a symbolic impact. So they are aiming to be recognized as children, as young generation, as victims of climate change, and to achieve the recognition that the state has also violated their fundamental rights. Both cases are also similar in that they are also aiming to policy objectives. So in the case of the Center for Biological Diversity, they were aiming to stop some carbon intensive project in the Arctic region in particular. In the Juliana case, they were aiming to force the Obama administration, but in general the United States administration, to adopt a comprehensive climate plan. Both cases achieved just a partial legal success. So the claims were not fully endorsed by the judges, and this makes them even more interesting, or it makes even more interesting to try to understand what extra legal, extrajudicial impact they have achieved. And well, the relevant difference is, in this case, is that in the Center for Biological Diversity, the symbol used was a non-human symbol, an animal. And in the Juliana case, we can say the symbol used were humans, so children. And therefore, we try to understand how this difference in the narrative affected the reception of the two cases. The methodology, trying to go a bit fast, we have proceeded in steps. So first, we have done a keyword-based search in two newspapers, United States American newspaper, the New York Times and the Wall Street Journal. We have chosen these two newspapers because they are among the ones that are more broadly read in the by the American public. And yeah, so we've just done a general research on the polar bear and on children in the way they were framed in the general climate change debate. Then we have expanded our sources, so we have also searched in the media archives from the Center for Biological Diversity and Our Children Trust to see how the commentary of the two cases was shaped. And in this case, we have collected, analyzed, and screened around 100 articles. And then we have proceeded to carry our content analysis that we have based on discourse analysis and on media framing literature. And I'm going to go a bit deeper on this. So what we have done has been first to understand in which way these two symbols have been represented by the media, so with which frames, and then which of these frames were more dominant, were prevailing. Then we've also paid attention to which agents were involved in the cases, so to which agents were given more voice in the media and the type of relationship between those. So for example, the Obama administration and activists and their relationship as a relationship of conflict or agreement, and also to the moral bias of the newspaper or of the author's attitude and the lexical choices used. So here you can see a first graph regarding the framing of the polar bear in the climate change debate. On the left, you can see the result from the New York Times, and on the right, the results from the Wall Street Journal. And well, one first thing to notice is probably that we have many different frames, especially in the New York Times article. And this is also because the polar bear debate was a very polarized one. And to each frame, we can say it corresponded one with an opposing meaning. So the polar bear was framed as a victim of climate change, but also as unaffected from it in a minority of articles, as a symbol of climate change, especially for activists, but also as a target for climate deniers, and both as a positive instrument for climate policy and as a negative instrument. So as a not legitimate interest for climate, not legitimate instrument for climate policy. It is also interesting to see that even though it seems that in both newspapers, that the two newspapers correspond in the dominant frame, so in both cases the victim frame is the dominant, in the Wall Street Journal, considering the different political orientation of the newspaper, the victim frame was used, but was also very much criticized and put in doubt. What we did when we analyzed the way the polar bear was framed in commenting the case was to pay attention not only to how much to how the frame were distributed in absolute terms, but also relative to the agents. So to the people that actually were expressing their opinions. What we've noticed in this kind of article is that often the author does not explicitly express its view, but tend to give voice to some agents such as activists or scientists rather than others. And from these, we've also derived a bit the attitude and the opinion of the implicit opinion of the author of the article. What we've seen here is that activists were the dominant agents, so they were the ones that were mostly interviewed. They represent the polar bear mostly as a victim of climate change and also a lot as a moral device, so as a moral reason to take action. What is interesting is also to see how this corresponded to the article's author view. And here we can see that the authors also resonated his view that the polar bear was indeed a victim of climate change, so there was not a denial of climate science, but other frames such as the one of the moral divide that were so important for the activists did resonate much less. Going now to the children, so we proceeded with the same methodology. Well, what jumps to the eye at first is that we have less frames. So in this case, to categorize was more simple and there was less polarization around the children and the children case. So the children were represented in the New York Times as either victim of climate change for reasons that you all imagine, as moral device also to take action, and finally, especially over the recent years, as activists. In the Wall Street Journal, children were not framed though as moral reason to act, but rather as instrument of climate politics. And here we can see the different political orientation of the two newspapers, whereas the New York Times tended to echo the liberal discourse on climate change, so this idea that we have to take action because of our children's future, whereas the Wall Street Journal expressed different kind of views. What is also interesting is that the activist frame generally had a very positive connotation, or a quite positive connotation, in the New York Times. So it was seen as a good thing that the children were directly taking action on their future on climate change, whereas in the Wall Street Journal, children were not really taken for full. So they were either considered as disruptive forces, as litigious in cases where they took legal action, or also just as children, so as too naive to actually understand what they were doing, so as a victim of instrumentalization. And here, what is interesting to see also in the commentary of the Juliana case is that the debate is generally more inclusive. So we have more interviews to activists, but also to the lawyers that were supporting them, and to other lawyers who were external to the case, to the judge, to scientists, to other NGOs. Well, this is quite obvious. The most dominant frame in this case was the one of the activists, but also the one of the victim, the children as victim, was also quite present, and this is due to how our legal, or the Western legal system, are constructed, so that people have to prove that they are victim, that they have been violated in some of their rights in order to bring a case to the court. And also what is interesting is that children are, yes, seen as teens, but in a quite positive way, so as rather as a hope than as a disruptive force. So going to the conclusions, we found that children replace the polar bear in its role as a symbol of climate change. So while the polar bear loses territory in the media, especially starting from the loss in the climate case, children gain increasingly more space, and increasingly more so as active drivers of change, of climate action. We've also seen that the frames are often politicized, so even though we find the same frame, they might be meant in very, very different ways. And with regard to the specific commentary of the case, well, the polar bear case was very important to initiate a conversation about the polar bear, and initiate a conversation about the Arctic region in general, and about climate science. On the other hand, whereas the victim frame was dominant, so was very much established in the media, other frames, such as the one of the polar bear as a moral reason to act, had a lower resonance in the media. The Juliana case, on the other hand, was not so important to start a conversation about children as victims of climate change, or as activists, because there were already other youth climate movement, and this was only a part of the puzzle. On the other end, we found that even though they were politicized, the children's role in the climate change action, or in climate change debate, was much less controversial. So both the activist and the victim framing were less controversial than the polar bear ones, and the debate was more inclusive. And I'm done, and I thank you very much for the attention, and I'm looking forward to the Q&A session, and in case you have questions, you can also address them in the mail. Thank you very much.
Thank you so much for your presentation, and thank you both for the great work that you have done. Okay, so now that we end up with all the presentations, it is time for the question and answer session. I already see some questions, but if somebody else wants to ask something to the speakers, feel free to just use the available feature, or chat, or raise your hand if you want to ask your questions directly to the speaker. In the case that you want to speak directly to the speaker, there's no problem at all. We will allow the use of your microphone and your camera. So, okay, I will start with the question that was sent in through the chat, though I cannot see who did it. But the question says, Dear Dr. Wyatt, green criminology is a new issue for Latin American countries. In that sense, I would like to ask you that in order to apply this type of law, we would need to study the human being as such, and the causes of why they have arrived at illegal activities. Would this be the case?
Yes, hi, thanks. And thanks, Carmen, for the question. I think I'll start with the beginning and then come back to your point about green criminology in Latin America. So, you're right. I think that my talk and some of the earlier talks are very kind of theoretical, or possibly even, kind of utopian a bit of how we could change things. But clearly how we change things is understanding human behavior. And you're right about understanding motivations as to why people are committing illegal activities. And that's integrated in, and maybe people are committing environmental crimes and for a variety of reasons. Maybe it's poverty, maybe it's speciesism because they're prioritizing humans, greed. We have lots of motivations or causes why we might be committing illegal activities. And you're right that I think that's integral and included in our radical shift of how we have a different relationship to nature. Regarding green criminology being new to Latin America, I'd say that maybe not so new. I think it's Dr. David Rodriguez Goyes, who I mentioned earlier, has been very instrumental in having green criminology presence in Latin America for several years now. And he and Nigel South have written an excellent article, I think maybe just 2 years ago, about how, even though it wasn't called green criminology, Latin American criminologists have been writing about the environment for decades, and we're really on the forefront of challenging criminology as a discipline to be more inclusive of the environment. So I think there's actually a much longer history than is often known about Latin America's contribution to this field.
Okay. Okay, so now in the question and answer feature, I have another question from Carolina Lopez. It says, good evening, my name is Carolina. I am from Ecuador, Galapagos. Congratulations to everyone for your interesting presentation. I have a question to Tanya Wyatt. The ideal would be to implement prevention policies or politics and also environmental education to avoid crimes against wildlife. However, in societies, we have where there are criminal groups that frequently commit this type of crime. Do you believe that the increase in penalties for that crimes would work as a preventive measure to avoid the commission of these crimes?
Yeah, thank you, Carolina. I think I've probably had a bit of a change of heart around this in the last year to 2 years. Some excellent work by Dr. Justin Marceau at the University of Denver, talking about how it's a bit of a contradiction for people like ourselves who are advocating for better treatment of wildlife to then be advocating for super punitive punishment to humans, where we know that that is also incredibly problematic. Prisons are brutal places. They're, at least, I mean, I can speak to the US and UK context. They're racist institutions that are contributing to social injustices. So whereas I take the point that we want to be more punitive in regards to wildlife crimes and to environmental crimes, to send the symbol that they are equal or on the same level as crimes that we see against humans, I can understand that. But I think across the board, we should be looking more restorative and reparative, and being much kinder and compassionate. And I don't think that super punitive kinds of approaches are achieving anything that they set out to do, regardless of the context. So I know that there's proposals about being, and certainly this has happened in the UK, that we've gotten much higher sentences and much stricter sanctions for wildlife crimes and environmental crimes. And maybe that would work against corporations, maybe your harshest, most committed kinds of offenders that would work against. But I think for the vast majority, we should be looking at restorative and reparative approaches to punishment.
That's great. Thank you. Thank you so much, Tanya. We have another question from Guillem Rubio. He says, good afternoon, Dr. Tanya Wyatt. Thank you so much for such an interesting talk. You have mentioned that we must unsettle the notion of crime beyond the boundaries of legality. I was wondering how this would include those farm non-human animals we use for food, whose entire existence is always framed within the legal paradigm. from conception to life and afterlife. In contemporary environmental discourse, animal farming is usually perceived as wrongdoing, only when it is harmful to the environment, greenhouse gas emissions, water pollution, etc. This usually neglects the life of animals themselves. In certain nature protection discourses, cows, pigs, or salmon are not even considered part of the earth as worth preserving. What tools do we have to contest this hegemonic view? How do we include them in this earth-centric approach?
Yeah, so I think that the earth-centric approach would include so-called livestock, right? So farm animals or companion animals are dogs and cats, as well as wildlife and other species. And obviously, if we take this earth-centric approach and we have legislation that's earth-centric, this completely disrupts farming as we know it. Not only livestock farming, but probably crop farming as well. So your plant agriculture too. So I think this isn't something that's going to just happen overnight and we're going to completely get rid of factory farming. This is something that's going to have a real gradual kind of introduction. But I do think that an earth-centric approach would include all of these other species too. But you raise a great point there, Guillaume, and thanks for the question. And I don't think it necessarily means everyone has to go vegan, but I just think it means that our relationship with the animals we are exploiting for food would be completely disrupted.
Thank you so much, Tanya. Do we have any other question? Okay, here in the Q&A, we don't have anything else. Does somebody else have any other question for, oh, here, chat. No. Any of the panelists wants to ask anything? Oh, another one for Uriol. Bea says, Uriol, thank you for your standing presentation. Could you elaborate on the idea of a glass ceiling for an environmental state? Uriol? Oh, the microphone is off.
So thank you for the question. It does open a lot of questions, the concept of glass ceiling, which was traditionally applied to gender questions. Now we understand that there are some things that we would like to do, but we don't understand how far we can push them. All the fight, and the environmental field is a clear example of the difference between and the distance between what we would like to achieve as a society when we look at the prospects of a better world and what is actually done. And here we talk about not only the cultural understanding of what is the citizen entitled to do and what are the corporations entitled to do as well, but altogether in the international fora, which is increasingly suffering from less and less common understanding of clear subjects that are cleavages in our international society. So we're gonna increasingly find this difficulty in making changes happen whenever they are structural. It takes a lot of time to understand how, and this has to do a lot with the economic structure of our societies. When we think of a better prospect, we don't put the focus on changing the structures, the capitalist structures, which is focused on the short-term goals and increasing of growth production. And then constitutionalism is rather biased in terms of accepting at this point other constituencies more than institutions and corporations and individuals. So it's going to take a little bit of time. And as Dr. Wyatt said, a lot of education to include progressively other scenarios? It's a very broad question that is cross-cutting too, the glass ceiling for an environmental state.
Okay, thank you so much, Uriol, and thank you so much, Beatriz, for the question. We just got another question. It's from Marcelo. He says, hello, everyone. I would like to address a question to Daniele. Could you provide an example that you studied of technology use in this context? It is a common practice in Brazil. Thank you for your presentation. The subjects are really important for society.
Thank you for a question, Marcelo. Yes, for sure. The investigation of the federal policy, for example, investigation of environmental crimes for deforestation in the Amazon have used these technologies at the service of the environment. I don't know if you have seen any news about it, but in December 2020, there was the largest seizure of legal timber ever recorded in the Amazon, the Brazilian Amazon. Around 200,000 cubic meters of timber in logs, if I'm not in error. And from what it is public, this federal policy operation was based on satellite monitoring provided by the Planet system, which is the one I mentioned in my presentation. So yes, it is a reality. And yes, it can be used to enforce existing environmental laws.
Okay, thank you so much, Daniel. Now, Deo is doing another question. He says, thanks to all the panelists, your presentations are very thought-provoking. I have a question for Carlota. Do you see any links between climate denialism, especially in the US, and COVID-19 denialism? If so, do you think this has the potential to affect the narratives around the climate movement?
Yes, so thank you very much for the question, Deo. Yes, I mean, I see a link between climate denialism and COVID-19 denialism. I mean, on one hand, the source is often the same, or at least very similar, and I think the ground is the same. It is a form of skepticism. We don't know whether a reasoned, strategic skepticism or a real skepticism towards science in general. And yeah, a rise in conspiracy theories when the COVID-19 is regarded, but also with regard to climate change and the use of power also to pollute the scientific debate. So in this sense, in the way they happen and in their responsibles and yeah, in the grounds for it, I see a lot of linkages for sure. I'm not sure if I understand the second question, like if the link between the climate denialism and COVID denialism can affect the narratives around the climate movement. Maybe you can speak up and elaborate or rephrase it. I don't know if that is possible. Otherwise, we can continue this conversation via email.
Deo, if you want, you can just speak.
Yes, sorry. Thank you very much, Carlota. You already answered, and I just wanted to gather your thoughts on this link and how it could affect the narrative around all this climate movement. So this is skepticism on science in general, how it could affect sorry. how it could affect the responses we have towards not only climate change and in the post-pandemic world. But thank you so much for your answer. It was exactly what I was asking.
Yeah, maybe if I can add something.
Yes.
An interesting result that we found was that there was, well, less skepticism when the symbol of climate justice was more sympathetic to people. So when there was not an animal being used as a symbol for climate change, because the empathy towards animal seems to be lower and more connected to some kind of ideology, some kind of way of thinking. But what we found is that these children-led movement are also very powerful because they are apolitical, or at least they are transcending the political differences. It is hard not to be empathetic towards children and towards their future. So in this sense, also the skepticism, also this cynicism that is often used in certain kind of media was less frequent in articles commenting on children and in climate movement. So yes.
Thank you.
Okay, thank you so much, Deo, and thank you so much, Carlota. It's been really interesting. Do we have any other questions? Okay, I cannot see any other question. So I'm going to move to the next section, and if there's any other question, please feel free to post it in the chat. So maybe after the concluding remarks, you can answer it, or maybe through email, whatever you prefer. It works. We are inside the timings, so we have time to answer questions later if you have any other one. So okay, now moving forward, last but not least, it is time for Dr. Rahma Bentiro, who will offer us the concluding remarks for this year's colloquium. Rahma, thank you for being here. The floor is yours.
Thank you. Thank you very much for this invitation to speak at this international colloquium, and thank you to the organizing committee of TIEC for this beautiful management and conception of the program. It is with great pleasure that I take the floor today among you to make some concluding remarks, which is an exercise of recapitulation that is quite delicate. So I hope that that I will be up to your expectations. The theme of this symposium was about environmental law and the challenges of the decades ahead, promoting transformative and to restore responses to the global emergency. And one of the answers I wish to give to these global challenges is to rethink the dynamics of legal systems as responses to environmental challenges and planetary emergency. Before going into the details of the subject, allow me to make a few remarks on what has already been said and debated at this symposium. First of all, it is clear from the different interventions in this symposium that the planetary and environmental challenges are studied from an interdisciplinary and even multidisciplinary perspective. It is therefore impossible today to conceive the study of issues related to planetary and related to the limits and the environment by involving only lawyers and only sociologists. Action must be carried out within a framework of synergy, reciprocity, and mutual interaction between the various actors. Finding transformative and restorative answers for the planet requires, above all, the mobilization of institutional actors and civil society in this process. So this is the first remark. This is the interdisciplinary aspect of the answers to be found for planetary emergencies. The second thing to notice, according to the debates advanced in the colloquium, is the close relationship between the issues related to the environment and those related to the protection of human rights. These are two completely different fields of study in terms of content, in terms of substance, but they are two disciplines that coexist and must coexist in the future. These two fields of study are so broad and complicated that they are able to cover many other issues related to the ethics, related to human dignity, related to common heritage and global values. It is within this framework that we are dealing today with the problems related to indigenous peoples or problem related to climate change, to vulnerability of certain populations and vulnerability of certain groups. The ethical question and its relationship with environmental law plays an important role in the understanding of this type of issue. And it is in this framework that I wish to highlight a very instructive intervention of Dr. Angelica de Freitas y Silva, not only the ethical issues, but also the gender issues, which are nowadays treated in a very careful and original way in connection with the protection of the environment and the planet. Dr. Farhana Sultana has highlighted the feminist, very original approach to feminist reading of the protection of social, structural, and material injustices in climate change and COVID-19. Third thing I would like to emphasize is the multitude of approaches according to which we can deal with environmental issues today. We are talking about the human rights approach, economic approach in relation to environmental responsibility, ecological approach, but also a very original and important approach, which is the international criminal law approach, precisely this emergence of the concept of green criminology and earth jurisprudence. Dr. Tanya Wyatt emphasizes this importance, the importance of law as a tool in the transformation and the restoration of the planet through the more global approach in understanding environmental crimes. I find her approach and her reading very engaging in talking about earth justice and not only climate justice or environmental justice. Through those different readings, I think that one of the answers we can give to the planetary challenges is to rethink environmental law in general and rethink environmental rights in particular through a dynamic of legal systems. That is to say, law should not longer be thought as a tool for finding solutions, but should be conceived as a complete system and as a laboratory for analysis of all planetary problems. When I speak about system, I'm referring both to norms and justice. Legal systems today, in the face of global challenges, must work in a mutual way. In my opinion, it no longer makes sense to talk about international law and national law in isolation. International law, European law, national law, regional law must be mutually connected. The question of how to deal with global dangers is no more a state question. It is a global question that cannot be restricted by territorial or by atmospheric or legal limits. It is for this reason that I evoke the concept of the dynamics of system. Dynamics is a Greek word from dynamikos or dynamis, which means the force. Sometimes in the physical sciences, the word is used to design the study of the motion of some object, of some mobiles. Dynamics of system refers to the forces directed towards a progress, directed towards a development. Therefore, it is important to interrogate the law on its transforming forces, and not only on its forces that create the rule of law. In this context, we can take the example of European law, and in particular of European courts, the Court of Human Rights and European Court of Human Rights and the Court of Justice of the European Union, which have shown a beautiful model of jurisprudential synergy. Justice of the court, European Court of Human Rights, do not hesitate, for example, to refer several times to the decision of the Court of Justice of the European Union, and vice versa. European Committee, for example, of Social Rights, which is a body of the Council of Europe, has also drawn inspiration from these two courts to develop its understanding of the right to health, for example, or the right to a healthy environment. There is also the example of the French court, the Affaire de Siècle, which represents a beautiful example on the force of justice in the condemnation of the states which do not respect their environmental responsibility. So the dynamics of legal system through the norms and through justice. Certainly, theoretical questions are always beautiful to treat. The practice and the implementation is always the most difficult thing, especially when it is a question of conciliation between planetary challenges and other challenges related to what I call the state or economic egoism of states. I think then that for the years to come, a lot of work on the mentalities and on the law is waiting for us and for our future generation. Thank you very much for your listening, and thank you also for all the staff of this symposium, for this management, for this organization, and I hope that for next year we can meet each other in Tarragona and not only via Zoom. Thank you.
Thank you so much, Rahma. That was great, honestly, thank you. Now I would like to ask to the whole organizing team to turn on their cameras. Who are we missing? Are we missing someone? Simona? Yes, Simona.
Fanny, Simona, Clara. Who else are we missing?
Hey. Okay, so is everyone here now? Is everybody here?
I think I hope so.
Yeah.
Yeah.
Okay. Well. Okay. So from the whole organizing team, we would like to thank you so much to both the speakers and the attendees for these 3 amazing days that we could share with you. We look forward to seeing you again next year, hopefully in person, though, as Rahma said, to what is going to be the 7th edition of the colloquium. So thanks a lot, because without your inputs and your interest, that would never have been possible. I will say one final thing, and then if one of my colleagues want to say something, please go ahead. The final thing that I want to say, though, is that we'll just share with you a link with a survey. So it would be great if you could fill it and let us know what are your thoughts about the conference and any feedback that you want to give us. It is really helpful for the following editions that we will carry on. So if any of my colleagues want to speak or say something, please go ahead. No?
No, I think, no, just to thank to all of you. And I think this a good opportunity to take a photo of all of us. If the panelists can turn on the camera, it would be great to have a memory for. Cool.
Hey.
Sabrina.
Simona. Well, maybe she wasn't ready.
Yeah.
So let's take.
Hey.
So thanks to all the panelists, the keynotes, the attendee, and of course to all the colleagues of the organizing committee. And we hope to see you the next year in Tarragona in person.
Yeah, hopefully that would be nice. So yeah, well, thank you so much. I don't know if we take any photo. Deo.
Simona is here.
Okay. Okay, cool. So
Thank you.
Yeah,
Thank
you, everyone.
For everything.
We will upload the videos in our website, and we will say it in our social media, so they will be there and you will be able to check them. And I just want to say thank you to everyone.